When legal proceedings happen in the middle of the night with participants arriving through back entrances and signing confidentiality agreements before entering the room, you know something significant is unfolding. When the person at the center of those proceedings isn't notified in advance. When even experienced legal analysts wake up struggling to confirm the hearing actually happened, you're witnessing a development that changes the landscape entirely. And when the word that keeps circulating among seasoned federal prosecutors is unprecedented, not the overused version, but the real kind that makes people go quiet on the phone, you're looking at a moment that will define everything that comes after it. To understand why this matters, you need to understand how federal legal proceedings typically work. In normal circumstances, even sensitive cases follow established protocols. Parties get notified. Lawyers prepare responses. The machinery of the justice system moves with a certain predictability that allows everyone involved to anticipate next steps. That predictability serves important purposes. It ensures fairness, protects due process, and maintains the appearance of a system operating according to established rules rather than arbitrary decisions. What happened after midnight wasn't that. A federal courtroom convened with extraordinary secrecy. The judge presiding wasn't the one who's been handling the publicly visible aspects of this case. Different judge, different courtroom, same defendant. When courts shift judicial authority in the middle of proceedings for something conducted under seal, there are limited explanations for why that happens. Each of those explanations points toward the same conclusion. Something new entered the case that required a separate track, a separate authority, a dimension of the investigation that couldn't be folded into existing structures without compromising something that needed protection. Federal. Courts seal proceedings for specific reasons. Grand jury activity when indictments are being considered. Witness protection when someone's safety is genuinely at risk. Ongoing covert investigations where public disclosure would compromise operations still in progress. Classified information with national security implications. Cooperation agreements where someone has decided to talk. Every one of those categories tells you something about the seriousness of what's happening. And every one of them suggests that the threat facing the subject of that hearing is more substantial than what's been visible in public filings. The detail generating the most concern among legal observers is the lack of advance notification. When a legal team of significant size and resources gets caught off guard by a federal judicial proceeding involving their client, it means the proceeding was structured deliberately to prevent that notification. That's not an oversight. That's a calculated decision reflecting a judgment about what would happen if the information moved in advance. If lawyers knew it was coming, something would change. Someone would be contacted. Evidence existing in one form might exist in a different form by morning. Federal prosecutors don't make that kind of inference casually. They make it when patterns of behavior give them specific grounds to believe advance notice is actively dangerous to the proceeding. Behind the public posture of outrage and demands for disclosure, sources describe a legal team scrambling to understand the scope of what they weren't told. They're running scenarios about what a sealed federal proceeding at this stage could mean. They're reaching out to contacts trying to piece together information that helps them understand what happened before. They walk into any open proceeding where that sealed development might have implications they're unprepared to address. For a legal operation that has positioned itself as always several moves ahead, being behind on information represents genuine strategic vulnerability. The political dimension can't be separated from the legal reality. Every development gets processed immediately through campaign machinery, becoming a data point in narratives about persecution and weaponized justice systems. The secrecy itself becomes evidence in stories supporters already believe about what's being done to their candidate. Legitimate legal reasons for sealed proceedings get stripped away, leaving only facts that confirm existing suspicions. That creates real danger for the institutions involved. Judges face threats. Prosecutors face harassment. Courthouse staff face intimidation. All of that intensifies when proceedings happen secretly. Investigators knew this would happen. They made the decision to proceed anyway. That tells you how seriously they weighed the alternative. A proceeding disclosed in advance, giving the opposing side knowledge and time to prepare, carried risks they considered more significant than the predictable backlash from secrecy. That's a consequential judgment made by people who understand the stakes completely. Sources are careful but suggest the proceeding involved testimony rather than documentary review. Testimony from someone whose words under oath constitute information that changes a case rather than simply adds to it. The difference matters enormously. Documents build foundations. Testimony from the right person builds structures on top of them. When you seal that testimony, protect the identity of who's providing it, convene in darkness to hear it, you're dealing with someone whose account has structural significance to what comes next. The possibilities being discussed quietly fall into several categories. Someone inside relevant organizations whose knowledge covers specific periods under investigation. Someone at financial institutions who processed transactions and whose account completes pictures that documents alone leave incomplete. Someone in foreign jurisdictions whose cooperation required arrangements that don't happen quickly. Someone in political circles whose knowledge of conversations directly addresses questions about intent. Any of those would justify extraordinary secrecy. Any would explain the timing, the separate judicial track, the decision to proceed without notification. This isn't about routine case progression. People describing what happened aren't using routine language. These are professionals who deal with standard legal developments regularly enough to recognize when something falls outside those boundaries. What changed overnight isn't just another filing or another hearing. It's the architecture of what's been building, the timeline that seemed to point toward certain horizons, the legal exposure that appeared to have certain contours. All of that is being reassessed in light of proceedings that happened while most people slept. When investigations reach stages where they can move at night in sealed rooms without telling the other side, it means they're not gathering information anymore. It means they have what they came for, and they're deciding what to do with it. The gathering phase is over. Something else has begun. What that something produces. What it ultimately means for someone who has consistently bet that no legal proceeding would fully reach them. Those questions don't have complete answers yet. But the answers are forming in rooms we can't see, in documents we haven't read, in decisions being made by people who aren't talking publicly. Here's what's clear. Something enormous shifted last night in the quiet of a sealed federal courtroom. The full weight of it is still descending. The clock that started running doesn't pause for political strategies or public rallies. It runs on its own timeline toward its own destination, with the quiet certainty of a system that has finally decided it's ready to move. For analysis that helps you understand what these developments actually mean beneath the headlines and the noise, subscribe to Allura Updates. Because the moments that change everything don't always announce themselves loudly. Sometimes they happen after midnight, behind closed doors, with only a handful of people in the room. And by the time everyone else realizes what occurred, the landscape has already shifted completely.